Good morning. This is the Incarceration Prevention and Reduction Task Force Legal and Justice Systems Committee. It is August 13th at 11:31. I'm going to start by reading the land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connections across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders, past and present. Please take a moment to consider the many legacies of violence and displacement, migration and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. Right. Welcome, everybody. So we've got the call to order, and we'll start with the implementation plan for this Legal and Justice Committee. And the implementation plan was attached. The main portion of this is Project 13. And the description is continuing to make changes in our court systems to reduce the number of people who are incarcerated and the length of time they are detained before trial. So that is why it's being brought to the Legal and Justice Subcommittee, is because that's one of our roles, is to see what we can do. And so I'm going to open it up for discussion. I know I did briefly speak with Judge Jones on some thoughts that he had, so I'm going to see if he can weigh in, and then I'll give you an update on what I've done so far since that discussion.
All right, thanks, Raylene. Good morning, good morning, everyone. Nice to see everybody. Okay, so I guess I'll give an update on some of the court's thoughts that we've had around these issues over the recent history, last year in particular, and kind of what the results, if any, of those efforts have been. The court has consistently been concerned and talking about these dual goals from the Vera report that we're aware of to, one, reduce the time to trial for pretrial defendants, how long a case takes to move through Superior Court. And then the second goal identified in that report to reduce the amount of unnecessary court hearings, or to make less more effective court hearings, more meaningful court hearings. So in thinking about those two issues, we discussed modifying our local court rules that would change a calendaring procedure in Superior Court that we thought might encourage faster case resolutions. So we put those proposals on paper. Every year we have the ability to change our local court rules and submit those changes to the state for adoption, and then become enforceable local court rules. So we put our ideas on paper, what we thought could increase efficiency in the court system is to eliminate one of our court calendars. We call it the status calendar. It's a calendar every week where the judge simply inquires whether a case is ready to go. We have it's a pretty long calendar, but also incredibly routine, and not a lot gets accomplished there. So we advocated through this court rule change to remove the status calendar and instead replace it with a system that would allow the parties to designate, just by filing a document with the court outside of court, that a case was ready to go to trial, confirm a case for trial that way, rather than at a court hearing. The rule would also allow the court put a time limit on which those continuance requests could be made, and would allow the court to note for court hearings cases that were over a certain length of time. And we had advocated 18 months being a reasonable amount of time that a case could age of a case prior to its confirmation by the court, or at least a hearing on the case held in court. So So anyway, we drafted these court rules. They were somewhat modeled after what Skagit County does, but we weren't aware of any other court system that was implementing these changes. We weren't exactly sure that the changes would be meaningful, but we felt like something maybe should change because we wanted to pursue quicker cases. We put those rules out for public comment. In particular, we sought input from the parties that are affected by this. So the public defender's office, the prosecutor's office, the local private defense attorneys. We held a meeting with those stakeholders. I'm glad to see Ms. Vanios here, Mr. Ritchie's here. I think they were both at that, or at least representatives from their office. Ms. Vanios was there. I'm not sure. Yeah, everyone was there. The feedback we got was pretty strong. It was from both of those stakeholder groups thought that these changes were untested in the way that they might not create the efficiencies we were after. And that it was kind of searching for a problem that might not exist. And that the other things could be changed that might better pursue these goals. So the court decided, in light of that input, to back off these changes for this year, to kind of to think more about process changes that could make a difference. And so we did not submit those particular changes to the state to change those rules. So we're in a that's where we are currently. We're in a process of thinking about these things, but not having changed to anything. Well, I take that back. The one thing we did submit as a change, even after the meeting, was the idea to move. We previously had a 24-month outside limit on when cases could be continued by agreement. Starting September 1st, that has been changed to will be changed to 18 months. So prior to 18 months, the parties, meaning the defense attorneys and the prosecutors, can submit agreed continuances. The court will sign those continuances off the record. After 18 months old, a case has to be called in court for the purpose of getting a continuance if that's what the parties are asking for. So that's the only change that's been made. That was a really long explanation. I apologize, but that's the process that we went through in the spring.
Thank you, Judge Jones. I see Sheriff Tanksley and then Peter. And I also did see Bertie's hand up earlier, so I want to acknowledge that. But we'll start with Sheriff Tanksley and then go to the next.
Well, I certainly appreciate that update from Judge Jones. But I was wondering, is it possible that the sheriff's office could be invited to those meetings? Because it does affect the sheriff's office and our capacity in the jail. And I keep a running list of folks that have been in the jail over 365 days, a list of people that are awaiting trial. I know at the end of June, we had at least 21 individuals that were still here for some form of murder charges, whether it was murder first or second or attempted murder. And as we look at the capacity of the jail right now, and as we look at in the future, modifying booking restrictions that we currently have now, being part of those conversations would certainly be welcome.
Yeah, I think that's a good idea, Sheriff. You know, these by state law, what we're obligated to do is propose rule changes, and then we put them out for a 30-day period of public comment. So it's kind of a generic, if anybody has any input on this rule, please make your voice heard. But I hear your point about reaching out maybe more specifically for input from the sheriff's office. I think that's a good idea. Yeah.
And then Peter.
Thank you. And thank you, Judge Jones, for the update. Really appreciate it. As you know, I've been talking with all three parties in that discussion over the last year and a half, probably trying to get a handle on an understanding of how we might be able to handle the court backlogs that are so concerning. And the reason I am particularly hot on this issue is that we will soon be in a position where we will be determining the size of our new jail. And until we have an idea of our throughput in our court system, I don't know how we determine an appropriate size for the jail. And we certainly don't want to overbuild based on incorrect data or systems that can be changed. And so I'm very interested in this conversation. I really encourage all parties to consider who has. I'm concerned that none of the parties particularly have a incentive to make hard changes. And I'm really ready to be proven wrong on this and would just love to have a robust discussion around how it is that we can be helpful in moving this conversation forward before we get to that very important point where we're determining how large this jail is going to be. Thank you.
Thank you very much, Peter. I appreciate that. In light of this, and a prior conversation I had with Judge Jones, he asked what the possibility was to run a report on active caseload docketed cases with trial dates excluding warrants. So you should see that shortly in your emails. I asked Jill to circulate it. The report has been ran, and there are 502 cases currently. There's 59 pages of those cases with information on that. So that gives you a little bit of a number, which might help the judges look at those cases and determine how to move forward with future rules. So I think we've talked before, and sometimes we go in circles with this of trying to get the data so we know what we're working with and how to move forward. And I know that the task force was working on getting somebody to do data for the county, and we need to continue on that, because in order to be able to assist in making changes, we need to know what we need to change. So that's part of it.
Let me, if you don't mind, Aileen, I really appreciate that, because I think, and I would appreciate this group's perspective on that number that maybe we can generate, or you've already generated that. That seemed to be in what happened in the spring, that seemed to be the missing piece, is that we just didn't have the ability, or didn't feel like we had the court, didn't feel like it had the ability to determine whether changes we were making were going to make a difference, could make a difference to the backlog. Whether we were just meddling without the ability to determine the benefit of our meddling. And so having a number like the number of cases that have active trial dates set, and the ability to monitor that on an ongoing basis, will give us some tools, some better tools to say, okay, what we're doing is helping, or it's not, it's making it worse. So I appreciate that.
Excellent. So I think, I'm gonna need a little bit of help from AOC on pulling certain things, because as much as I was proficient in a different world, in a different program, I'm still learning in this one, and it's not always easy to manipulate. So I know that data is important, and AOC has been helpful and responsive to my requests. So it's just working through all the other processes to get what we need to move forward and not backwards. Maya and Eric, do you have any comments in reference to this at this time? I see no hands.
Yeah, I mean, we participated in the conversation with the court, and I think we, in terms of deciding whether they were going to move, well, giving our input on whether they should move forward on those proposed rule changes. And it contemplated adding some calendars, changing some calendars in ways that I think we all reasoned really weren't more efficient in terms of attorney time in court. And I appreciate it. I thought it was really thoughtful. It was good to have some new proposals come up and examine them closely. And I think we need to do that periodically, as the court does. And we are open to those discussions at any time, because we always want to try to be more efficient while not sacrificing our clients' participation and rights. So thank you for that, Your Honor, and we remain open to those conversations. But I don't have any particular suggestions today. I will tell everyone about your coming rule change to 18 months, though, so that they know. Thank you.
Yeah, can you all hear me?
Yes,
Yeah, I don't see my
Yes.
face up there, but anyway. Yeah, I was there at the meeting and I thought it was great. I really appreciate the court speaking to us. I thought we had a nice open conversation and feelings were heard. I felt like we really had a good conversation. The one thing I was looking for was more judicial activism, and I think that we're getting that with the court getting involved in our cases after 18 months. And anyway, I think that's going to be helpful. I really didn't have a comment other than that. Thank you.
all right. Thank you. Peter?
Yes, this is a question, and keep in mind that I am not part of the legal system and my knowledge is really, really thin. So I apologize if I can't get my terms right and such, but it does seem that there might be an issue around calendaring, in that my understanding is that a defendant might be seeing multiple judges on multiple appearances, and my understanding is this can be lead to a problem where that lack of continuity can lengthen the whole process of their case going through the system. Could somebody speak to that and tell me, is that correct? What can be done? Are there attempts to change calendaring in such a way that we might have an improvement there for outcomes? Thank you.
Judge Jones, can you answer that one?
Yeah, for my part, I think that's a pretty astute comment. Our calendaring system right now, it's just a rotation amongst the judges. So we take turns 1 week at a time doing what we call the criminal rotation. And that includes these calendars every week where cases could be heard for the purpose of requesting a continuance. So what does happen, and Ms. Vanyo and Mr. Ritchie, correct me if I'm wrong, but what I perceive sometimes happens is a particular judge will hear a case. That judge will say, this case needs to go to trial. It's too old to be continued. We'll set the matter for trial. Then that case then will spill onto some calendars the following week where a different judge will hear that. By that point, there maybe is a better articulated request for a continuance, or at least another request for a continuance. And then that subsequent judge, without the benefit necessarily of what the earlier judge was thinking about, will grant the continuance. I think that happens by just the nature of the rotation we go on. Maybe there's some efficiencies that could be created there where an old case will be put on some sort of specialized track with a particular judge, moving it towards trial in a consistent, ordered way. But that's a lot of micromanaging of cases, but it is a change that could be made or thought about.
Yeah, the clerk is actively taking notes of the judges' comments and decisions that are made at each court hearing, and I know the judges review those. I understand they review them before, or maybe simultaneously as the case is being heard. They're checking to see what happened at the last court date. And if the judges are saying on the record, this matter shouldn't be continued because of X, Y, and Z, or can only be continued if you present X, Y, and Z, that should be in the clerk's notes and being taken into consideration. And, it's very hard to get special sets in front of judges to track cases. Like, the time available for the judges is limited and precious. When a judge hears a matter on a Wednesday status hearing and it's confirmed, and an omnibus hearing is set the following Monday, and that's an opportunity for the parties to ask for a continuance, but it's also the time when the court is evaluating if the case is ready to go or not. It's often a different judge, but sometimes big issues can change in 4 days and there's a good reason to continue it. But I don't think I don't identify that as the problem, because I think there is adequate communication and record keeping in the clerk's notes that if there's the parties on the bench kind of know what happened the last time and what the direction was. And if there's a need for a change of direction in a case, it's because the parties are making an effective argument that it is needed. So I don't know. I mean, I guess like we could try new things, but I do think scheduling is very difficult. Time is very precious. Special sets are really hard to get. And I don't want to take away from that special set time that is available to create a system that I don't think that this, I don't see that part as broken, but maybe Mr. Ritchie sees it differently.
I'm gonna circle back to Heather, as I see her hand up and a lovely little one.
Hi. Um, I have a little report, Raylene. I don't know if you'd be willing to let me share my screen and just share some of the findings. Prosecutor Ritchie allowed me to do a mini case study on a random sample of prosecutor files because a couple of years ago, continuances was coming up as a reason why the jail was full. And I wanted to understand why and what's going on in some of those numbers. And I can just share really briefly, if you're okay with that, Raylene, what I found. Let me share and scroll through.
Great. And Heather, will you have Jill email that out to all of us too?
Yes, as long as Prosecutor Ritchie's okay with that. Yes. And can you see the prosecutor files analysis here?
Yes.
Yes.
Okay. So this was a random sample, and it was just me going through page by page a few different files from each prosecutor's shelves. And the findings that I found were that 35% of the cases that I analyzed had been open for 1 year or less. So that means whatever 100 minus 35 is was 65. There we go. I'm tired. I'd take new mom privilege. 65% of the cases analyzed have been open for more than 1 year. And national benchmarking is that 98% of felony cases are resolved within 1 year. So that's like, that's 2/3, right? That's a big number we have to work on. Only 25% of the defendants were being held in custody during the time of analysis, and they were pre-trial and pre-sentence. 75% were out of custody. And of those held pre-trial, cases had been open between 400 and 800 days. And there were a variety of reasons. 2 of them had competency orders and restoration services requested. All cases had been in front of the court per their files between 16 and 26 times. And requests for continuances ranged from 5 to 17. All of the cases had a level of complexity. Some had additional bookings and charges during their time of open cases. And the unresolved initial case, one was noted as being in custody at Western State Hospital for some time. Another one was noted as being released to treatment for some time. One was recently rearrested and charged with assault, one with a knife. One had been at the work center for 522 days with a charge of possession of a stolen vehicle. And another is noted as sentenced at this time and serving at the work center with records indicating 873 days in custody. So quite a range. It was very clear that both prosecutors and public defenders have high caseloads, which I think makes it difficult to fairly and robustly process cases and support rehabilitative outcomes in timely manners. I did some analysis on the level of bail set. It had no correlation to length of stay in jail pre-trial or the severity of the criminal charges. I think opportunity for our community to look into. And I will say that 65% of defendants have a criminal record and history of more than 4 charges. One had as high as 36 prior arrests and charges, and 43% had charges beginning between the ages of 12 and 17. So that's like another indicator of we got to do better for our youth, right? And 70% of cases had drugs involved as part of the crime charge or history of the defendant. These were my recommendations that I'd just like to put out there for the public record. I think benchmark case processing times and add staff capacity or resources to meet those standards, which I know is an ongoing conversation with both, I think, prosecutors and public defenders. Many of the cases had behavioral health factors associated with the crime, um, and a need for, I think, trauma-informed approaches, sometimes for both the victim of the crime and the defendant. And I think if a social worker was able to actually review the files in partnership with prosecutors or public defenders, there could be additional referrals to services or interventions. I think training for prosecutors for what factors to look for and what would indicate in a case that a client would be good to refer to services or a program such as LEAD or GRACE could be good. I did highlight the provide additional support or systems for preparation for cases or calendars or time and case management, that new case management software may help with that, but it was, to my understanding, a paper file system and notations of the next trial date set. So each individual attorney had to track their own schedule to prep time adequately for each case. I also thought that maybe with the structure of the courtrooms, that what Peter was just saying, that if a case was consistently seen in front of one judge, it could help reduce the need for continuances, as that judge could maintain familiarity with the case and understand necessary delays in processing. And then a couple of other, add additional support. I think even just starting from the top of the files and looking through them occasionally, going 1 to 200, right? And seeing what's going on with each file. And if Prosecutor Ritchie allows me to send this out, you'll be able to see a deeper analysis of like number of court proceedings, how many times cases were in front of a judge. I did some analysis on how much that costs taxpayers when you think about the processing time. Length of time cases have been open, whether or not there is a deal offered, and then sorry about Booker, and the reasons why continuances were being asked for. So I just want to share that for the conversation, that there's, I think, a huge opportunity here for us to get some more efficiency out of this system.
Thank you. Can you scroll up to whether a deal was offered and explain how you got that data? Booker, oh,
sorry, team. Thank you, Sue. Welcome. Best team at Chuckanut ever. Let's see. I will share again. And so, was there a deal offered? If you wanted to go up there. This was just me actually reading through every page of the file I received and noting it by hand. Was there a deal offered or not? And when that, so I put you can see whether that person was out of custody or in custody, how many days the case was open, and then notes about the deal offered. And I found in this sample, half of the time a deal was offered and noted in the file. A deal was offered in 2 out of 20 cases where the defendant was being held in custody, and in 8 of the 20 cases where the defendant was out of custody. And I think that there's an opportunity to do this kind of meaningful analysis so that we can actually start to talk about what should the response be from the system, and how should deals be offered and when, and all of those factors that play into the languishing of a case. Whether they're in or out of custody, shouldn't the goal be efficiency for tax dollars? So
this is the total cases that you examined for all the data that you created, is that right?
Yeah.
Okay, so it looks, I'm just guessing how many are there? Is it maybe 20 or something?
Yeah, 20 files.
Got it, thank you. And I'll let you know, and Eric can confirm that twice in the last, I don't know, I'm guessing now maybe 6 months, maybe a little longer. I did like a random draw of open cases. I just pulled them randomly, noted whether offers had been made or not, and sent that over to the prosecutor to say, hey, look, here's a random sampling of 20 cases. We don't have offers in X number of them. Appears to be a lack of communication. So I did that a while ago, and then I did it again fairly recently. And those conversations are active between the two departments because, and I think with, you know, the information I'm getting from the prosecutor's office is that with their new case management system, they're putting in some tickles and triggers and steps in place to make sure that offers are going out. I could explain why it's sort of complicated and case by case, but generally speaking, having an offer come from the state is what will begin to trigger the community. It helps move along communications towards resolution. It is not always our client's stated desire to propose a resolution. We don't always want to negotiate with ourselves. We want to kind of see where the state's evaluation of their evidence is. And we may differ dramatically about that and then eventually come to a meeting, or we may remain at odds and never agree about what the evidence shows and have to litigate the case. But I think Eric Sigmar, who I talked more with Eric Sigmar about this issue, but I think they are working on trying to get those offers coming to us more regularly and in a more timely fashion.
And I'm like Peter, I don't know what I don't know, right? And I just want to offer that this is a slice of analysis that in the absence of any real meaningful data, it's helpful to kind of see like what edges are we
Yeah.
talking
Oh, I
in
think
this-
it's wonderfully helpful. Thank you. And I look forward to looking at it and reading
Yeah.
it like after this because I have never seen it. And you've identified, I think, issues that we are in our practice identifying as obstacles. And I just wanted to share that we are communicating about those and trying to work on them. But I love your list and I want to look more at it.
Thanks, Maya.
Yeah, and I'll say for the courts part of it, I haven't seen that data either. So Heather, thank you for presenting it, putting the work. I know that probably took a lot of work.
It did.
Yeah. And you know, the court's role is we recognize that the parties can be doing things on their own that have nothing to do with the court that result in earlier case resolutions, getting together, making offers, evaluating their evidence. All that stuff has nothing to do with the court. The court sees, though, like in the absence of that occurring on its own, the court sees movement when we do things like confirm a case for trial over everyone's objection, because then all of a sudden offers are being made and people are forced to confront the realities of the cases. So that's kind of where we sit on the outer edge of if things don't happen on their own, then maybe the court calendar itself should allow the court to push it. That's
Mhm.
what we are. Yeah.
So on this, and this could be good for you to help me understand too, and help the public understand who might be watching. So I looked into, there was a continuance of what was the reason listed. And I also recognize the data is only as good as the completeness of the file. So if whatever was written, right? And out of these, there were about 76% or 100 times defense asked for the continuance. And I also recognize that the burden is on defense to do that. And some of the different reasons here. So 66 times no reason was listed, but a lot of times there would be working on a resolution or there's outstanding discovery, defense needs time to prep, investigating case, having trouble contacting victim. There's all sorts of complexities to the continuances. I recognize that. But also, one thing that I think is important is that 25% of the time, defense wasn't asking for the continuance, that the state also asked, multiple parties would ask, the court moved to continue a few times too. And the one interesting thing about the judges to me is when there's a reason listed, like we're anticipating resolution, and then if 3 months go by and that's the same reason for the continuance that comes up, but it's a different judge, how are we able to hold anyone accountable in the system to say, well, you said that last time and why didn't that happen? And like, I get that there's a checklist that you're all going through in the system. And so it's just an interesting aspect to me.
I'd like to address both of those. I mean, first of all, the 75% I think is not a good number, because it would be more appropriate to look at agreed and unagreed, because the state marks that it's a defense request for reasons of speedy, they're trying to protect speedy trial, but it's agreed between the parties. So it's kind of disingenuous to say that it's a defense request. Neither side is asking to confirm for trial. So more accurate would be when a continuance is unagreed. And is it unagreed by the defense? Is it unagreed by the state? Who's asking to go to trial? Who's not ready to go to trial? And on your last point about continuances, oh shoot, I was going to try to write it down really fast, and oh shoot, can you pull your thing back up for a second? Because I think it would remind me what I was going to say. Your chart. Oh, it was the last thing you said about consistency with, someone says, I'm continuing it because we're anticipating resolution. And then 3 months later, it hasn't yet happened. Now that with the rule changes where the judges are saying, if your case is over now 18 months, but it has been 24 months, they have to be heard on the record, explanation has to be made. I think there is a lot tighter overview of those kinds of statements. Like if it's noticed, if that same thing is said more than once, sometimes it has to be said, because if the person is, for instance, anticipating to enter into mental health court, but it can take months and months to do that, and maybe the person has to successfully complete inpatient treatment before they can. There's so many millions of, there are many reasons why you could anticipate resolution in a case and it wouldn't happen within 3 months, that it in fact takes longer to get there. Maybe the person is to pay some restitution beforehand before they can get the deal, or I can think of lots and lots of reasons. So, but I think that is being examined a lot more since the court started requiring us to make a record at the status calendars on Wednesdays. Thanks.
Without the crying baby, I can just scroll through so you can see a little bit more the analysis and again, this is just what was noted in files, and I get that it's one slice. I'm going to scroll through that one quickly, but this was really compelling, and I think this would be a good topic for this committee in the future, that age of first arrest and how many charges and arrests they carry in the system. It's like what this is saying is this first arrest was when this person was 12 years old. They have 36 arrests in and out of the jail, in and out of the system. And I think that that's like a big philosophical question for our community to grapple with that, like, most of these young cases start in some sort of drugs or trespassing or vandalism. And is the system working to help them not recidivate and actually help them rehabilitate and get on a different path or not? And again, I know it's complex. Did some analysis on the bail and the difference in what prosecutors and defense asked for and what the judges actually set, and was there any correlation with that? And so there's a lot of different interesting things to look at in this, even just in this 20 file sample. And I do think statistically it is significant if you can get shockingly small samples that show some statistical significance. So thank you for letting me share.
Thank you so much, Heather. I'm so impressed with what you provided for us today. Maya, I see your hand up yet.
Thanks. I mean, I definitely could obviously have this conversation for a lot of, I want to talk about every single data point that you have and understand it all. But as to the youthful offenders, youthful adult offenders, I mean, that's one of the things that we've been working with Northwest Youth Services. They've written a grant. We're trying to get funding to create a young adult defender or young adult diversion program. We'll find out, I think, next month if that grant was permitted, which would give some staffing to support it. But then it's like we'll need so much more. It'll need the services. It'll need case management, like with lead. And I mean, it's just a seed of a beginning, but I agree with you that like we have to address youthful adults and what's going on with them to prevent the recidivism and do it meaningfully. And I know that and again, I mostly talk with Eric Sigmar about this project, but he attends those meetings. He says that the prosecutor's office is on board and is gonna divert people to this program if we can build it. So we need to build it. Thanks.
Thank you, Maya. I'm hoping this gets shared with everybody. I think once we can dive into it a little bit more in depth, there might be more conversations and questions and things that we can come up with to make the system better. So I really do appreciate all the work that you've done in it. Timeliness is a key factor for the courts and everybody trying to get cases to move quicker. Because a lot of our court system is also based on memory and what happens. And so a delay in proceedings doesn't help with the memory as well. So I think it's important that we evaluate this and see how we can move better as a group and collaborate on things that we can do better. I think the new case system management program that prosecutor's office is going to be helpful. I also think they're working on a new process to provide discovery quicker. I think that will be very helpful. But anytime you're trying to do something new with new staff or with training, it takes a little bit. There's hiccups, and I see that as we have a turnover in our criminal clerks and getting people trained and getting the data that they need to make decisions on all sides, whether it's the judges or prosecution or defense. We have to make sure the clerks are providing an accurate record in a timely manner as well. So we all have to work together on this. I know that the bail amount was also a description in Project 13. I know that's something that you looked at. We did have a conversation about that. I believe Judge Rands and I think Judge Anderson and there was a few individuals that discussed the constitutionality and how that works in our current court system and what things can be evaluated. It might be something we need to discuss a little bit further down the road, but I don't know if that's a subject for today without evaluating some of those numbers a little bit more, unless somebody else has more input on that. And today's conversation has really circled around Superior Court. I wonder if Jake or Tammy have any input on the municipal or district court on their cases and timeliness. I think Jake has just been inundated with trials a lot in district court.
Yeah, thank you. We're just doing some research recently about cases filed and like post-COVID, pre-COVID, and number of trials we're running, and we're averaging just through the summer at least two a week. And so we're just doing what we can to make sure those happen efficiently and happen whenever necessary. I will add, we're talking about a little bit about the consistency with judges, and it gets tricky when there's trials. Then they need to go to see a commissioner, or very often lately we've been bringing in pro tems because of affidavits, and that kind of brings another element into that as well. We do our best, obviously, in record, the logging of court slips and then the docket to review what has happened, and we do our best to make sure we continue to make those efficient as possible and continue to roll as the judges would prefer. But it's just another added element that to deal with, that to unpack and make sure that we're doing it the right way. But yeah.
Thank you. Another item that I think kind of falls under the courts for the justice implementation plan is to review statutes and laws and rulings that can impact how we proceed with justice implementation. So I think I sent around a case of State of Washington versus Sean Slankler. I might not be pronouncing that properly, but it was a Court of Appeals decision, recently published opinion, and reference to right to counsel and communicating secretly with counsel during hearings. And essentially, this individual was charged with, I believe, 5 counts, felonies, and the Superior Court remanded the prosecution back for a new trial because they said that his rights were being violated because of his constitutional right to privately confer with counsel at critical stages of the criminal prosecution. And I think, our judges are doing a really good job at making sure that they have the ability to try to speak with their clients. This opinion came out of the COVID area with remote hearings. But as we move forward to looking at building a new justice center, we have to make sure that there's adequate space for defendants to meet with their public or clients to meet with their defense attorneys. We have to make sure that there's courtrooms available for those defendants to be brought into them. It can't be an afterthought because we want things to happen in a timely manner. I think Judge Jones is familiar with this case. I'm assuming Maya and Eric might have some information on it if they want to weigh in on this. But I do think it's important as we build a new center that we look at all aspects and not just part of it as a court responsibility. Is there any other changes that we think we should be looking at through the court systems for Project 13, which is in the Justice Implementation Plan? Okay, I'm gonna go to Peter because I see his hand up.
Thank you, Raylene. Well, thank you very much for that really good discussion on continuances. I would love to see us continue to keep that door open for that discussion and look for solutions as we hurtle towards the day where we are going to determine the size of our jail and its features, as Raylene just brought up. One other thing that I would like to put on the radar, we probably don't have much time to discuss it today, and I don't know all that much about the ins and outs of this, but I am looking for opportunities for us to make a difference in diverting from our jail, and I see the potential of electronic home monitoring in the Superior Court setting like we do have elsewhere. And again, because this is really not my area, I don't know all the ins and outs of that, but if we can see that there is a big jail population difference to be made in electric home monitoring for Superior Court, I'd really like for us to take that seriously and see if we can make some headway again before we determine size of the facility. Anything anybody has to say would be of great interest to me. Thank you.
Yeah, I think we need to, and then maybe pretrial services can help with this. I don't know, because it just, or like the population in the jail, it needs to be determined like what percentage of them would even meet the eligibility requirements for that and could meet. I mean, many of them, our clients don't have homes with which they could utilize such a program. So I guess I don't know. But those are the kinds of things I'd want to know that would help decide the utility of it, or whether we're just gonna be adding electronic home monitoring to all the people who would ordinarily just get PRs. I mean, the court has supposed to use the most least restrictive conditions for release. That's what the rule requires them to do. From the defense perspective, I'm always worried that we're just going to add conditions to folks that would otherwise have been PR'd without that condition, and that we aren't going to really get to the reducing the jail population, because nobody's going to give somebody charged with an assault with a deadly weapon electronic home monitoring for liability reasons. So like, are we just overburdening? Are we creating more obstacles for a population that doesn't really need those kinds of onerous restrictions? Or will it really be used on these more serious cases? Like, is there going to be, I don't know that it really would be used that way. Like, it might just create more obstacles. Thank you.
I think that's a fair point. You know, our population in Superior Court is different than, say, District Court, where they are able to utilize this more efficiently. That's true. It seems that there are cases that might, though. I mean, there are cases in Superior Court. I think Ms. Fanner, you can agree that it could be an alternative to incarceration. And I'm thinking of cases where, you know, the risk concern is violating no contact orders, offenses against a particular victim over and over again, and maybe some sort of geographic awareness of where the person is at all times, and an immediate reporting might help alleviate that risk for the commissioner who's making the decision. So there are some cases, but I think starting with an analysis of that population is a good idea.
And on that note, Peter, I think, you know, Tammy might be able to provide a copy of the requirements that they use for home monitoring. And it, you know, allocates whether or not, if somebody's in warrant status, they couldn't confirm a warrant at one point, but maybe there's a warrant status and somebody's got a warrant somewhere else, so they're not going to necessarily want to put a bracelet on somebody and release them here, when they know if they do that, that bracelet's going to be cut off if they're picked up and the warrant's confirmed in another jurisdiction. There's a lot of other requirements, and I see Tammy took her mute off, so I'm going to let her speak to that just a little bit. But I know pretrial services is also looking into it.
Yeah, I mean, we love being able to use the bracelets, but we have to look at their past history and determine if they can be put on a bracelet instead of being incarcerated. You know, we also have people that are being booked for domestic violence, and we're not going to send them back to stay at the home that they committed a domestic violence attack, you know, or allegedly, and have them on home monitoring there. You know, we do utilize it for the safety of the victims too, with the active GPSs, and we try to do it as often as we can, so we aren't overburdening the jail system with some people. It's like some people will release them with a scram order instead of holding them on bail, so we know that they're not consuming alcohol and not being a risk to the community. So I hope that kind of helps too, so you understand a little bit of how we are doing our best to utilize these bracelets.
Thank you, Tammy. Any other questions?
Tammy, it's friendship diversion services that you use. Am I right about that?
Yeah, it is.
Have you found them to be, maybe we can talk, but any concerns about the you know, them being responsive and capable monitors of the bracelets, that business?
We have found that they are extremely capable at monitoring. They are always in communicate when we have, say, an active GPS, they contact the defendants through the bracelets if they see that they're coming within the restricted zone prior to them crossing it. They also will contact law enforcement if they see that they have willfully broke that restrictive barrier that they're not supposed to be passed. If they have any type of violations, they are getting those to the court, to the prosecutors, to probation and defense. So everyone is aware of the activity that our individuals are having on the bracelets.
Thank you.
Yeah.
Thanks, Tammy. Is there any other conversations in reference to the implementation plan at this moment? Excellent. We timed this good today. On other business, I have been actively seeking out somebody to assist with the chair position on the Legal and Justice Subcommittee. It's been a struggle. Some people have volunteered, but their elected positions don't allow them to do it. Stark Follis said that he would be interested in assisting with that. We have to figure out how that would work because Maya is also actively on there, but I think we can have anybody on the committee to assist in the chair position. I just wanted to float that out there to see if there was any comments or discussion on that.
I'll comment. I support Stark.
Okay, I appreciate that, Eric. Thank you. I just, I love helping out and being part of these groups, and I'm not saying I want to walk away, but I do also need a little bit more support because I can't always be here. So I want to make sure that these meetings continue in a robust fashion, and then we have somebody else to help lead. I think that would be beneficial. And to get a different perspective. I think that's important. So is there any other, oh, I see Peter's hand up.
Do we have any private attorneys on this committee? I'm just curious whether that is any recruiting that this committee should be doing. I think it would be great for us to look for gaps. If we could get a citizen or two on the committee with a mind towards the legal and justice, that would be great. I don't have anybody in mind necessarily, but just wanted to throw that out there, Raylene.
Okay, I appreciate that, and I think I can think of a few different people if they're interested. A lot of the private attorneys in the criminal justice field, I'm recruiting to take conflict cases, which is a continued struggle with defense in the public defender's office and conflict cases with our conflict office, and not having enough attorneys to go around for those cases will also impact the judicial system in delays. And so that's my first priority, is to make sure there's representation for individuals before throwing them on a committee if they have time. But I will definitely reach out to individuals I know on that matter. So thank you. Okay, I don't see anybody else's hands up, but I will proceed with Jill to see if there's any public comment.
Thank you. We do have a number of attendees in our room today. If you would like to speak to the committee, please virtually raise your hand now. We do have one hand raised. Dean, go ahead.
Yes, this is Dean White. I'm a temporary part-time special project manager within the Health and Community Services Department. And I wanted to make sure everyone is aware that the county has issued a solicitation for proposals to develop a performance management plan for the Justice Project. And that's going to be, proposals are due this Friday, and I think they're hoping to assign a contract next week. And the reason I mention it is that I'm, Heather, really impressed by your formative research that you did, and I guess I want to make sure that that material is available to whoever it is that the county contracts with to develop that performance measurement plan. So just wanted to make that point.
Thank you, Dean. I appreciate that.
Is there anyone else who would like to speak to the committee? Please virtually raise your hand now. No hands raised. Peter, is there anyone with you in the conference room?
There is not. I'm here by myself.
Thank you.
Thank you, everybody, for a good meeting. I'm gonna go off to my next one. It is 12:30 and this meeting is adjourned.